whether we use this for the broadcast or not, when I came in here, I said, right on, let's get going, right? That reminds me of a story when I was in basic training back in the 1970s. Most of the people in basic training are 18, 19 years old, enlisted people. Some of them are a little bit older, but we had a guy in our group, in our company. His name was Phillips, and he came in as a PFC rather than a private because of the fact that he was a Vietnam vet. So he was one of these guys that served his time in Vietnam, got out, and played with civilian life for a little bit, didn't like it, came back. And, he he might have been 35 years old, but he looked like he was 45 years old. A very rugged-looking guy from the South, weathered face, and he talked with a Southern accent. And I'm thinking, man, how does this guy even do this? Here he is getting yelled at by these people that probably weren't war veterans, probably younger than him. And this guy's been shot at, right? He's been discharged honorably from the United States Army, and he's back in basic training getting yelled at. I mean, that is thick skin. So one day, the platoon is in formation, and one of these drill sergeants starts, rah, 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 rah. Isn't that true, Phillips? And he goes, right on, drill sergeant. And the guy stops, kind of like a Jackie Gleason moment, who you don't know who Jackie Gleason is, but he stops and he goes, Phillips, what did you say? Right on, drill sergeant. He goes, you know what? Every time I call your name for the next 4 months, you're going to say that. So it was constantly, Phillips, right on, drill sergeant. Right on. So I don't know. I guess we're talking about, being in some difficult situations as family law attorneys. And sometimes, we feel like we shouldn't have to put up with the abuse sometimes that we do by various people in our profession, whether it's an opposing counsel. Some of them are crazy. Sometimes they're rugged judges. Sometimes even our clients are a little insensitive to us. And I guess in my mind, it's right on, baby.
I like that.
So anyways, how are you doing?
I'm doing well. How are you?
Good. So you just took a little time off.
Yeah.
My associate, who's a workaholic, that you actually made me proud. You took your work with you. That was really good.
Yeah.
You were in Santa Barbara.
Yeah. It was beautiful. It was the perfect weather. It wasn't too hot. It wasn't too cold. No rain. There was an outdoor aquarium we went to, just impromptu.
There's an outdoor aquarium?
Yeah, so on the pier they have the aquarium.
I've been in there. Yeah.
And they brought it outdoors.
Oh.
And so you could pet like a baby shark and jellyfish, and it was really nice. I mean, it was just nice to be outside in the fresh air.
I was in the indoor one. I didn't know they can move that stuff outside. My daughter lives in Santa Barbara, as you know, and it's really one of my favorite places to go.
So good.
Yeah, and you had to drive. You couldn't take the train, right? Mm-mm. And you actually stayed in Montecito.
Mm-hmm.
Cool. So you got kind of an interesting story to tell about my workaholic associate attorney. Most people relax on their vacations. Most people, don't want to think about work. If you call me, I'm going to really bite your head off.
Yeah.
You, on the other hand, did a trial setting conference on your vacation, staying at the hotel, and you had a little bit of a problem. Could you describe that?
Yeah. So when this trial setting conference got set way after the vacation was planned, and because I didn't want to continue the matter, I was like, it's fine. How long can a trial setting conference be? I'll do it. We'll be in, we'll be out, we'll be on our way to go. And it occurred to me that our checkout time was at 11. Now, usually they're at 12. It was at 11. And it's like, it'll be fine. Everything will be smooth. These things are 5 minutes long. How long is it going to be? There's not going to be an argument. We need a date. So I call, at 8:15, and then I'm on hold until 10. And I was like, all right, what's going on? Why is the clerk not coming on? Is the judge running late? What's going on? So I grab another phone. I call the department. The department's not picking up. And I'm like, oh, God. So then I called Department 2, and I'm like, what's going on? And they were like, oh, we can't find a clerk. We don't know what to do. Just stay on hold. So then it's inching closer to 11. So I said, I can't. This is too much anxiety. I'm packing up as I'm on hold. Get in the car, hook up a hotspot. I'm on a laptop, in the car with my phone, and I'm texting you, trying to figure out clients emailing me. I'm just
I'll have to say, I never knew you were having this problem. You were cool as a cucumber.
Yeah.
But go ahead.
Yeah, I was like, okay, and I'm wondering, in Montecito, the reception was not so great where we were staying. So then I'm like, oh my God, what if and my phone kept timing out. It kept hanging up the call. So I kept calling back over and over again to the department. I was freaking out, what if they now answer and I can't get through? And it was just this moment of,
Okay, now I remember there was a certain point where you texted me and you said, I didn't catch all of the judge's beginning ruling.
Yeah.
That's what was happening. I didn't know. Okay, go ahead.
yeah. So then finally we get through, and I mean, this thing that could have taken like 5 minutes, it could have been emailed. I was just at this point, I was like, we should just email all the TSCs. This is so inefficient. And then, of course, it got continued to the next morning. And so I was like, come on. But I was happy that it wasn't like I wasn't freaking out like over the phone while the clerk is like, what is going on, counsel? Like, why are you screaming? Or why is there like a train moving by you or a car moving by you? So that was fascinating practicing in 2020.
Well, you know what? Actually, welcome to family law.
Yeah.
You know, I was talking to Casey the other day, and you know, she's going on vacation, and I said, you know, Casey, I don't know of one genuine family law attorney that doesn't work while on vacation.
Yeah.
You know, you're either answering emails or you're making court appearances. I made a court appearance while in Florida, I think a year or two ago. I was literally in my swimsuit. Casey, I had to stand in for Casey because she was on, I think, maternity leave, and I might have even had a little cocktail, and I'm sitting in my condominium, and the hearing was in Sacramento. So I don't know the judge, I don't know opposing counsel, and here I am making a
I
colorful
remember this
argument.
case.
Yeah, you remember that case. Doing my best to be serious about this. Oh my God. So that's a vacation for family law attorneys.
Yeah. You remember a couple of months ago, there was a Supreme Court argument that they had, and on record, one of the attorneys like flushed the toilet.
Yeah.
And they just like aired it, and he just casually was saying his argument, and it just, oh man, what fun times we had.
Yeah. Our etiquette has to be guarded, somehow.
Mm-hmm.
Yeah, especially since we're doing so much of the remote calls, way more than I even imagined, and it's a lot easier. I mean, we could talk about that, at some other time, but yeah, we've got to be careful.
Yeah.
So let's talk about a topic for you today, because you recently was involved in a case with me that involved an opposing counsel
Yeah.
putting into record
Yeah.
evidence of medical records of a child.
Mm-hmm.
So, you got a husband and wife, they're fighting over custody. One of the parties says, hey, you know what, Judge, you ought to know that this child has mental issues, and I'm going to prove it to you. Here's a copy of the report from the psychologist, and put it into evidence. You had a problem with that, didn't you?
Yeah.
So why don't you set it up for us?
Sure. So typically, when we're dealing with person to person, so spouses to spouses, this issue comes up a lot too. Oh, they're crazy, and here's their HIPAA. It says HIPAA on top, but here it is. I'm publicly filing it, and that's a different issue, because then you could say, I'm the holder of the privilege. That patient is the holder of the privilege, and I said no, you can't file this, and if it's not tendered by me, you can't file it. And that's how it goes. And it's a lot simpler. When you have a kid, it's like, well, who holds that privilege? Do the parents hold the privilege? Does the child hold the privilege?
So what's a privilege, by the way?
Privilege is, so we have some things called privilege information, which this information doesn't get out. So most things do get out. There is a duty to disclose almost all information, but communication between attorneys to their clients, your doctor to the patient, psychotherapy or therapist to the patient, those are all protected, so privileged.
And why are they protected?
Well, they're sensitive information, and policy states that people will not be truthful if they know, hey, down the line someone's going to file this and, come against me. If my client can't be candid with me, they can't get advice. It's just not going to work, because they're going to filter themselves out of fear. So we want those things to be protected. And it's a really big deal. We have a lot of evidence codes, a lot of procedural codes on that. So this is a very important issue. But with kids, it's even more important.
And it poses a dilemma or a question that a lot of even family law attorneys aren't aware of, is if you got husband and wife, neither one of them could consent that the child's records are coming in, right?
Yeah, so just to kind of take it back a little, most people don't realize that what they file is public with the court. There's a policy, it's actually a constitutional law, California constitutional law, that says everything needs to be public record out of policy. That's just our Constitution. And so if you want to not make that public, you want to, privatize something, which we would call seal it. So, you have the clerk sealing something and it's out of the public domain, the public doesn't have access to. You need to do a motion And it's not like a family law analysis of it's not in the best interest of the child. It's a constitutional law analysis, which goes to, I think, strict scrutiny analysis, which is like triggers to con law cases.
Very difficult to do.
It's very difficult to do. In fact, it's done in very limited circumstances, like if there's like egregious sexual assault, or you could imagine like celebrities that are super, super wealthy, some stake shareholder, whatever, is riding on this divorce. They might find a way to seal it or, file things under pseudonyms, which they have to get a motion from the court and permission to do. Those things typically might get sealed, but stuff like this is a little bit different. So with that said, some people don't realize that, hey, what you file is actually available to everyone. They can go get it. I mean, that's why like TMZ can get documents like so easily. So when an attorney does this, who would know that this is public record, there's like another layer of like ethics, I think, which we will get into. But coming back to your question of who holds this privilege, it's super important because everyone thinks it's the parents because, well, we have custody, so we hold the privilege and we can do what we want with our kid because we're the parents. And that's not true. That's not accurate.
Right. And I think what a lot of people might think because they don't know the law is, well, if we don't agree, then the judge will decide and just put it in there.
So my issue with this is, from a parent standpoint, parents, they're going through the worst of their lives, especially in dealing with kids. I mean, it's horrible. It's not a fun time for anyone. But I think, the other parent is going to say, hey, you're so desperate to want custody or to want time that you're willing to sacrifice our child's privacy. This is public. We don't know if their school is going to get it, their friends are going to get it, admissions is going to get it, employers are going to get it. What if they want to, go run for office? That's going to come out. I mean, we see that all the time. You are so desperate that you're not even thinking of this kid. You're just thinking about yourself. This is not in the best interest. And I mean, you bring that to court, I can count so many judges that might just like rip the other parent apart. I mean,
go ballistic.
Yeah, I already know two off the top of my head that will just like, and I think you know which ones I'm thinking about, which will say, how dare you do this to your child? This is not the way to go. So if you're the parent and you're telling your attorney, really want to get this in, really think about what you're doing to your kid. Because anything we talk about in court, by the way, is also public. So if you're going to come to court and say, my kid is horrible and terrible and, did this and did that and they really need help. They're crazy. Well, guess what? What if their friend is sitting in the audience? People do that. I mean, you don't know. What if your kid goes and gets the transcript? Then what?
A transcript's made. It's in the file. It's there 20 years later. She applies for a government job, and an investigator wants to look in the family law file.
Yeah. And background checks, I mean, people, if they want to find something on you, they're going to find something on you. There's actually a lot of jobs that will turn you away if you have even like a semblance of like you needed help sometime in some place because you were a teen and, God forbid you go and get that help and now this employer doesn't want to hire you because you're like 35 now, but, what you did at 13 really mattered. So it's really important to really kind of figure out what are you getting out of this.
Let's take it a little bit further. Let's say that there was a child that was sexually molested by, a neighbor, and there's an accusation that one parent didn't protect the child like they should, and they want to put in the mental health records of the child into the court file. Now, fast forward 10, 15 years later, should the public have access to that?
Yeah, and I don't think they should. I think that the thing with family law that comes together is unlike other laws where you can like stick to your guns and say, I'm not going to settle, there's no way, no how. You can't always do that here. You can't, being litigious is good, it's great. I mean, we all do it. But there comes a time to, cool off. And I've had a case where my client said, I'm really mad that mom did this and, our kid ended up doing X, Y, Z, and I need you to write that in the declaration. And I just said, no. I said, I'm not comfortable putting that publicly. We can reword it in a different way, in a more passive way, but at least we're not violating your kid's privacy. I'm not doing that. If you want to do that, that's going to have to be something you reconcile with yourself. She's going to see this. They're going to know about this. It's just not going to be good. Of course, client's not happy, But I think at the end of the day, that was the right call, and client ended up appreciating that down the line. But that's just something as an attorney, we talk about zealous advocacy. And there's an argument of like, well, I was just being a zealous advocate for my client putting these records in. But were you really? Because it's like, what's the end goal? At worst, you're going to have a judge say, counsel, what did you do? This is horrible, and I'm either going to sanction you somehow or sanction your client somehow, or I'm going to just sua sponte, on my own accord, seal it. On a lighter note, you're going to have an opposing counsel call and say, hey, what is going on? We're filing a motion to get this out. On another note, the courts say, okay, now you're deemed like an unfit parent, or you clearly don't know what you're doing. I'm going to order a minor's counsel. And now your client has not only been embarrassed in court, has had to incur extra fees. Now there's another attorney you guys have to deal with and split costs of. So what did you achieve?
It was going to be on the side of you're not going to put these records into, put the medical records into the court file. I'm asking for sanctions too.
Right.
Yeah.
And so, the way that I don't like this approach, but the way to go about something sensitive like that is, call the other side and go, hey, this is what we have. I'm thinking about lodging it. I'm not going to be okay with that, but at least I know it's not public. Now I know I could do a motion in limine. I could, maybe argue against it. I could read it and figure out what's going on. But at least it's not in the public. At least I don't have to do like an ex parte motion to get it out of the public domain. So that's another thing to take care of. And to answer the question, which, the whole point of this is who has the privilege. It's the child who has the privilege. It's neither of the parents. And I hear this argument all the time. It's the parents because they have legal custody, and legal custody is rights dealing with education and health and, the legal aspect of things. Well, even so, if that's true, which it's not, you still have to call the other parent and say, hey, this is what I want to do. Do you agree? And, of course, the other side's going to say, no, I don't. So that stops it right there.
Well, then you got to go in front of the judge and let the judge resolve legal custody issues.
Right.
But this is something even more than that.
Yeah, this is something deeper than that because it's neither of the parents. It's the child who holds the privilege unless there's minor's counsel appointed. Then the minor's counsel will hold the privilege because she's, the minor's counsel is the attorney for the child.
And that makes sense because you got a 5-year-old kid. You're going to ask
Right.
the 5-year-old kid, do you waive your privilege? What?
Yeah, what is privilege?
Yeah.
But the interesting part is case law about privilege when it comes to kids comes from dependency court. And a good argument, and we had this in the office, we did a brainstorming session, myself and another associate attorney, of like, oh, well, what if the court is like, well, in dependency court, you have a conflict of interest. Why would you give the privilege to the parent? Because the parent is trying not to lose parental rights. So obviously they're going to want the privilege. Well, what about in family court? Well, we have a case. Our office did an appeal, and it won on appeal. And one of the issues that won on appeal was that the child holds the privilege in joint sessions with a therapist, with their father involved. That case is not published for opinion, but what I'm trying to get at is that we're seeing that family court is going to side with dependency court, that they're not really far off just because we have the factor of dependency court versus family court. So that's an interesting thing to consider and to advise clients on who do want to do those things.
Cool. So
Yeah.
You actually had some cases where we won't get into names. We're not going to tell anybody about these cases, even though it's public record. But, in the particular case, the person was representing himself, and he initially tried to put in the records. You objected. He kept doing it. He kept doing it. Finally got an attorney. The attorney reluctantly withdrew the information. And then what happened?
And then we filed for sanctions.
Well, actually, if I recall right, what happened is then some time went by. We start setting it for another hearing, and guess what? Then the attorney submits the information.
Oh, right.
Yeah.
Yeah, I forgot about that fun
Yeah.
little tidbit. Yeah, that does happen, and it happens, I think, and here's why. I think it's a twofold, answer of why attorneys do this. And number one is they don't even realize they're doing it. I mean, I've gotten things filed where I've looked at it and said, this is literally communication between yourself and your client. Like, why did you file this publicly? Or it's like, I didn't mean to do this, I didn't understand, or I was so busy, I was trying to meet a deadline, and it just slips through. But there's always the case that they continuously do it over and over and over again. And that's where it really hurts my clients, because then I have to get on the phone, I have to write a letter, I have to document what happened, I have to get a motion for sanctions. And it's like I've spent so much money defending this, and we haven't even gotten to court yet, and we haven't even talked about the issue we need to defend yet.
Shocking, really shocking that attorneys would do that. I could see making a mistake. I mean, you
Yeah.
know, attorneys make mistakes, but when in that one particular case where he knew better because he withdrew it when his client did it, then he turns around and does it himself. You're thinking,
Multiple times,
yeah,
too.
yeah. So I guess what we're learning here is that we got to be on guard, right?
Yeah, and I think, you know, zealous advocacy stops when you're actually being unethical. Like, you can't just say, so I'm sticking to my guns and I'm moving forward. It doesn't work that way. You know, a lot of times just being civil helps the case a lot. Like, I've had a case where we needed to exchange, like, discovery, and I hadn't done mine. I hadn't received the other one, and nothing was really happening in the case. And I called the opposing counsel. I was like, look, I know, but can we just agree to a date? And she's like, oh my God, I've been so busy. Like, I didn't even know. Like, thank you so much. Like, yeah, totally fine. Like, we're great. Like, no one's going to sue and sanction anyone. We're fine. Like, there's no motions to compel. And it helped the benefit of our clients. No one has to now spend fees, you know, and that happens a lot. It's like, hey, there's one thing. Like, I had a opposing counsel call me, like, there's just one thing, and if you take that out, everything's fine. And I'm like, oh, well, I don't want to take it out because, you know, it's going to harm my client, maybe, kind of. Okay, well, let's think about language. Are you guys okay with this? Oh, yeah, we're okay with that language. Okay, let's do it. And now we've saved everyone, you know, going to court, doing mediation, time, money, everything's saved. So
I think your point is when confronted with a situation like this, you would think that the other attorney would go, oh, yeah, I'll take that out because that was a mistake.
Yeah, and it's also, I mean, when the law is not on your side at all, and I've already done like 3 motions arguing how the law is not on your side at all, and then you do it again, it's almost like now I'm mad. And now it's like, if you want a simple extension, oh no, I'm mad. You know, I'm still mad about how you filed these things publicly, and I had to spend double, triple time trying to fix it. And it's just frustrating. It's really, I think that's the hardest part when we're dealing with counsels like that.
Yeah.
Because that's not good advocacy. And I don't even think that's being zealous, because being zealous, you're just candid with your client. Like, no, sorry, like, we can't do this. Let's figure out a different avenue.
You bring, on that final note, let me say this, is that, you know, on one hand, the client might think, oh, you know, you got to do it for me because I need to win in this custody battle. But are you really helping that client with that client's relationship with the child?
Yeah.
You know, 10, 15 years later, the child is completely embarrassed. It's all over social media. And who is to blame for that?
Yeah.
But this, you know, wacko parent that doesn't want to think about the child first, you know.
And kids come, you bring a really good point, because kids come in different forms. Like, it's really easy to tell a 7-year-old or a 3-year-old what to do and, no, you're doing X, Y, Z because I'm the parent. Yeah, try that with a 15, 16-year-old.
Right.
You're not going to get anywhere.
Don't I know? I've raised 3.
So when that 3-year-old grows up and maybe, you know, isn't really keen and doesn't really understand what's going on in the case, they just know mom and dad or parents are fighting. And that 3-year-old grows up to be, you know, 16, 17, 18, and is like, hey, what happened in this case? And pulls all of that up. And I mean, that's just, number 1, traumatic. But number 2, like, how do you look at your kid and you're like, yeah, I was mad, and that's why I did this. Sorry,
Yeah,
you know,
yeah.
sorry, kid. It's just not worth it, like, the repercussions of it. And I think this is where we have to be, like, more human as family law attorneys. It's not like black and white and here's the law, therefore I'm right. It's like, well, what are you really doing? Is it
That's where
worth
the counselor
it?
comes in.
Yeah.
My first stint in family law, I was practicing with a guy that had been practicing for like 30-something years. And his business card, mine used to say this, I haven't added it to my business card in a long time, but it was attorney and counselor at law. And I said, what does the counselor mean? He goes, well, you know, we do more than just dispense legal advice. I mean, what we're doing is we're looking at the whole picture of the client and trying to give them advice that's going to give them results that's really going to make a difference. And I think this is one of those.
And here's the tricky thing about, being the other parent on the other side who's like trying to protect this kid's privacy, where, if the kid doesn't have minors counsel, it's like they're going home and they can't talk about the case with their kid, and they have to really be like careful to not divulge anything, to not say anything. And the kid is having questions, especially if they're older, like what is going on. And the first thing we say is like, don't let them know that the other parent did this to them. Just don't say it. Don't do that. It's going to even be worse for you and the child and the case. But it's really hard. It's really hard. And, we've had parents just call crying, like, I don't know what to do. What do I tell my kid? And we just say, tell them you love them, and you'll get better.
Yeah.
And it sucks. It's definitely the hardest part of this job sometimes.
Yeah, absolutely. Well, Mane, you're doing a wonderful job keeping us informed about all these nuances in the law. You're awesome. And thanks again for joining us. And we'll see you sometime soon for our next case.
Thanks. Always fun.
Okay. See you soon.